Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. Decisions made by this quasi-judicial board will be based on the evidence and facts presented tonight. Our meetings are conducted in accordance with Robert's Rules of Order, and each case will begin with the city presenting its evidence of the alleged violation. The respondents will then present his or her case, and both parties will have an opportunity to cross-examine all witnesses. The board members may question any witness. Comments by both parties must be relevant to the case. Persons wishing to speak will be given an opportunity to do so by the chair and must address the board from the podium after giving their name and address. Upon request, copies of the material submitted by the staff are available for review. Board members are reminded to obtain permission to speak from the chair, and questions of the city should be directed to the city attorney, the attorney for the city. At this time, I will ask all persons who expect to give testimony tonight to stand and be sworn in by the city clerk. Anyone that's going to be speaking on a case tonight should rise, please. Be sworn in.
Please raise your right hand. Do you swear or affirm that the testimony or evidence you're about to give is the truth and the whole truth, nothing but the truth?
The cases will be taken in order this evening, guys, so we will move right on in. Has everyone had a chance to review the minutes of the last meeting?
Yeah.
And were there any changes or comments?
No changes.
Motion to approve,
I'll make a motion to approve the minutes.
And I'll second it.
second by Mr. Westfall.
Point of order, Chair. Since this is my first meeting, I'll be abstaining on the vote for the meeting minutes, since I have no way to tell whether they're accurate or not.
You didn't get a copy.
I got a copy, but I have no way of telling whether they're
Yeah,
accurate or not,
okay.
so I'll be abstaining from this particular
Very
vote.
good. We have a motion and a second. All in favor?
Aye.
Opposed? No nays. Board members, I want to, before we get into our first case, is to introduce our newest member, David Poglorovich. He comes to us from the city council. He served them well. He served here on the board when I came. So, welcome.
Thank you. My pleasure.
Okay. Yeah, Mr. Mueller, this is your part.
All right, yes, at this time, I'd like to ask the board if they've had any ex parte communications regarding any of the matters that is coming before you today. So if you've had any verbal communications, if you could please disclose the sum and substance of those communications, when and where those communications occurred, and with whom they occurred. And if you've received any written communications, such as emails, please disclose the nature of those communications and then get them into the clerk for the record.
Mr. Poglorovich?
I've had none.
Mr. Hubert?
None.
Mr. Snelling? None here. Mr. Newkirk?
None.
Mr. Lloyd?
I've had none.
Mr. Westfield?
I've had none.
Thank you. First case, please.
Case number 18-2293, City versus Walfredo and Mayra Moreno for property located at 412 Courtney Drive. The case is before the board based on an alleged violation of Section 12860, inoperable vehicles, outdoor storage equipment. The case will be prosecuted this evening by Officer Jose Silva. The city has evidence that the notice of violation and notice of hearings were properly served.
Good evening, board members. Jose Silva, Code Compliance Officer. This case originated proactively May 30th, 2018. During my inspection, I observed a vehicle parked in the side yard of the residence with an expired tag. This time, I left the door hanger with a compliance date of June 2nd, 2018. On May 31st, I was contacted by Miss Moreno, the homeowner, who requested additional time for her husband to register the vehicle. She was given 2 weeks at that time. An inspection on June 26, 2018 revealed no change. Notice of violation was completed with a compliance date of July 6, 2018. No one was home, so I posted notice at the home as well as City Hall. Also mailed copies certified and regular mail to the address of the registered owner. On July 6, 2018, I was contacted by Mr. Moreno, who requested additional 2 weeks to get the vehicle registered. An inspection on November 19, 2018 revealed the inoperative vehicle with expired tag still parked in the side yard. This time, I have 2 photographs taken by me November 19th of the inoperative vehicle still parked in the side yard. I'd like to submit those.
Board will accept.
Thank you.
As of today, the vehicle is still parked in the side yard, and the resident's out of compliance.
Are there any questions for Mr. Are there any questions on this case?
So this is a single violation of expired tags and also parked in the yard, is that the,
No, sir, that's a concrete pad the vehicle is parked on.
okay.
Okay, thank you. Mr. Morano?
Yes.
Or
Might have to
Mrs., or
translate for
Mrs.?
him, so-
Okay, you need to?
Excuse me?
You need to translate for him?
I might have to translate
Okay.
for him. Senor,
Yes.
Okay, you want to present your case, what you want to say to the board?
¿qué es lo que tú quieres decirle a la gente?
Que me den por lo menos 30 días para ayudar a resolver el problema del
He would
carro.
like to have 30 days to resolve the issue with the vehicle.
Okay, he's had since July,
Tú tenías de julio para resolver.
Sí, pero no pude resolver porque tengo mucho trabajo.
He said
Yo
he hasn't-
trabajo en mantenimiento.
He said he hasn't been able to resolve it because he's had a lot of work.
okay. Since November, you were out there in November and it was still that way and it's still that way today. Has he ever made any comment about progress?
No, not to me. He's not made no comments about progress.
Any other questions? Mr. Glorovich?
What's his plan? What hasn't been done that needs to be done, other than going down to get the new tags? I noticed that the tag was
¿Qué es lo que
expired.
tú has hecho? ¿Qué planes has hecho? ¿Ir a coger una chapa nueva para el carro? ¿O qué es lo que tú has hecho?
Tengo que agregar el carro al seguro para poder ¿cómo se llama? Sacarle la registración.
He needs to get it insured so he can get a registration to get a tag.
Entonces, yo me estaba esforzando por el trabajo para ahorrar dinero para el seguro.
He's trying to get money so he can get it insured.
Okay, so this is not about mechanical problems, this is about money, just simply money for insurance.
No es problema de mecánica, es problema de dinero.
No, el problema de mecánica.
He said problems with mechanical also,
De transmisión.
transmission.
Is the vehicle currently operable?
¿Se maneja, puede manejar la máquina ahora o no?
Se mueve, pero no se puede transitar en la
He
calle.
said it move, but you can't drive it.
Okay. And he thinks he'll be able to solve the mechanical problems and the insurance problems and the tag problems within the next 30 days?
¿Tú crees que lo puede arreglar, arreglar la chapa y el aseguro en 30 días?
Yo creo que sí.
You think so?
Mr. Silva, this is for an unlicensed vehicle, and the tag is expired, and that's parked in the side yard.
Yes, sir.
It's not as an inoperable vehicle? Is that
It's-
correct?
Inoperable, expired tag, that's what, the way
Okay,
it reads.
okay. All right, Mr. Lloyd?
In the evidence you presented, the tag says 2014 was the last time that tag, is that correct?
That is correct.
Okay, and that tag does belong to that vehicle.
Bid 214 es el registro de la chapa esa. Esa chapa va al vehículo ese.
Sí, sí.
Okay, okay. Is there an alternate method that would satisfy the code violation that wouldn't involve insurance
Yes, there
operation?
is.
Okay. Have you discussed that with him, possibly? Because I'm concerned that 30 days is not going to happen if it's not operable, and we're in 2019. If indeed that evidence you presented said 2014, that's 5 years since that tag's been issued to that vehicle. So that's a concern I have, that maybe,
I can discuss with him
okay,
afterwards.
and hopefully he'll be willing to maybe do something there with that
Yes, sir.
also. Okay. I just wanted to make sure that there was an alternate method than what was previously discussed by, that Mr. Poklovich brought up with the insurance running and so forth, that he can come into code compliance for us without having to go all through that and be back here in 30 days going, I couldn't get this and this and this. Okay.
Any other questions? I want to thank you, Mr. Silva, for being our translator this evening. It's kind of a unique thing, we get to ask both your questions at one time. But any other comments that,
Cualquier cosa ahora quieren decir.
No, está bien.
okay, thank you. Is there anyone else in the audience that would like to speak on this case? There being none, I would like to call for a motion.
Vamos a sentarlo aquí.
I'll make a motion.
Mr. Lloyd?
Apologize, I have a new phone, I'm trying to turn it off, so that's, technology is stumping me here. Okay. Based on the testimony of Code Compliance Officer Jose Silva and Mr. Moreno, based on the testimony of Code Compliance Officer Jose Silva and Mr. Moreno,
Mr. Chair, sorry to interrupt. I know that we need a,
Translator,
I was
and
gonna
he's
say,
gonna have to translate this. I think they
Oh,
should
on
come
the
back
mic?
up to the podium, and we read this off so, and have it translated so he understands.
Okay. Thank you.
do we need to note that he was for the city translating for the, I just,
I would just
okay.
make this in phrases that it's kind of
Sure.
translatable so that we can
Okay.
have a smooth translation.
I'll give it to you in blocks, pieces. Yes, indeed. Based on the testimony of Code Compliance Officer Jose Silva and Mr. Moreno presented to the board at this hearing,
El testigo que José Silva y el señor Moreno le dio a ellos,
and the documentary evidence received by the board, I make a motion the board find
y los retratos que le di a ellos, que ellos buscan,
Mr. Welford and Mrs. Myra Moreno in case number 18-2293 to be guilty of violating section 12-860 of the city code.
Rodolfo Moreno y María Moreno, en este caso 18-22-93, con
And give the respondents until January 9th to come into compliance with the code sections in question.
le dieron que fueron culpables, tiene tiene hasta enero 9 para correctar.
If the property is not brought into compliance by that date, a fine of $30 per day shall begin to accrue on the day following and continue to accrue until the date the violator provides the city with evidence the property has been brought in compliance.
Si no está correctado por
En 30 días.
por 30 días, empezando el 10 de enero, 30 días, 30 pesos por día
Pero eso sería para el Nissan, ¿no?
para el Nissan. Sí.
Para,
Okay.
I'll second that.
I have a motion and a second by Mr. Newkirk. Any discussion?
Do we want to just make sure that Mr. Silva's confident that he got the translation? You feel he?
sí.
Okay.
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 Any discussion? There being none, call for a motion.
You have a motion to
I made a
a
motion, we
second,
do-
I mean,
And
a
the
vote.
clerk seconded it.
A vote.
A vote.
All in favor, aye?
Aye.
Opposed, nay? No nays? Mr. Moreno? There has been a motion, second, and there is if you do not come into compliance by January 9th, a fine of $30 per day.
Tiene hasta enero 9.
9.
Si no correcta el problema antes a enero 9, es 30 pesos por día la multa que va.
Will begin to accrue and will continue to accrue until this violation has been
La multa
come into
sigue
compliance.
Hasta cuando se correcta el
Hasta que esté
problema.
correcto. Okay.
Mr. Chair,
Yes.
would we maybe want to mention to him that if he's not able to, that he could attend the next meeting? If he's not able to do that? I don't know. That
Yeah.
might be-
I don't know.
Yeah, as
Okay.
Mr. Lloyd, as
I can-
Mr. Lloyd said, that if he is unable to come into compliance by the 9th of January, that, just to let him know that he can come back before us and he can ask for an extension if necessary. It doesn't mean that it would be granted.
Mire, si no puede, el problema no se puede correctar antes enero 9, puedes venir para acá y
Y pedir una prórroga.
pedir más tiempo.
Ok,
Okay?
ok.
Thank you. Thank you, Mr. Silva.
Thank you, sir.
Case number 18-3665, City versus Rebecca Mariana, for the property located at 406 Dunedin Avenue. The case is before the board based on an alleged violation of Section 12-860, inoperable vehicles, outdoor storage equipment. The case will be prosecuted this evening by Officer Jose Silva. The city has evidence that the notice of violation and notice of hearing were properly served.
We didn't give him much time in between, did we?
Didn't have timing there, sir. Sorry about that. Good evening again. Jose Silva, Co-Compliance Officer. This case originated from a citizen complaint on August 22nd, 2018. During my inspection, I observed an inoperative vehicle parked in the driveway of the residence with no tag, along with 9 other violations at the residence. This time I left door hangers with a compliance date of August 27, 2018. On August 27, 2018, I was contacted by the tenant and owner of the residence requesting more time to correct the problems at the residence. They were given until September 3rd, 2018. On September 4th, 2018, I inspected the residence again and noted all the violations were corrected except for the inoperative vehicle still parked in the driveway with no tag. Another inspection on September 18th revealed no change. A notice of violation was completed with a compliance date of October 13th, 2018. No one was home, so I posted a notice at the home as well as City Hall. Also mailed copies both certified and regular mail to the address of the registered owner. My inspection on November 19th revealed the inoperative vehicle with no tag still parked in the driveway of the residence. This time, I'd like to submit a photographic evidence of a photograph by me taken on November 19th, 2018 of the inoperative vehicle in the driveway of the residence.
Board will accept.
Thank you.
Any more further comment?
No further comments, sir.
Are there any questions of Mr. Silva?
Yeah, I noticed that there was a second violation on the handout that I have.
That's been taken care of.
That's the 9 or 8 or 9 that were already corrected, or? one of
Excuse me,
the-
sir?
That's one of the 9 or so that were already corrected?
Yes, sir.
Okay.
What happened with that filing on, that should have been taken off when I filed it, and that was a mistake on my part.
Is the
The tenant is here
tenant is
tonight.
here? Name and address, please.
Joshua Cottrell, 406 Dunedin Avenue.
How could you spell your last name?
Cottrell.
Okay.
So, as he said, there were a number of violations I corrected. This one, I can really do partially because of money and partially because I can't find the title. I got the money together at one point, but I couldn't find the title to get it registered. It was actually a gift from friends of the family, and I can't find the title, so I can't get it registered, and then the money got spent on other bills. So,
Yeah, have you tried to go to Tallahassee, go to the state and see if you can get a copy of this title?
there is a way to do that. I would have to contact the people who gave it to us, and it's a bit of a process for the both of us. And I haven't been able to do that, no. So,
Okay, is there any other comment?
no, that's really it.
Okay. Mr. Snelling?
So, do you have a plan to correct this problem? or-
I'd like to say I do, but the money is a concern, especially right now. I could definitely do it at tax time, but that's a bit, I don't know how long you guys are willing to give me. So,
Is there do you have a place where you could get it moved to store it off-site,
other than my backyard,
other than the backyard?
no, not that I could think of.
Mr. Lloyd?
Yeah. The vehicle, is it operational?
It is, actually needs a fuel filter, but other than that, it'll be fine.
If Mr. Silva's able to present some other options for you, besides the lengthy and costly process of getting the search done, is that something that you would entertain?
Oh, I mean, I'd look at it, definitely.
Okay. I do believe the state offers other options for you there, not being a person that works there. I think he would be able to help you out. The concern is, you mentioned tax time.
Yeah, it's a little ways off.
Yeah, and, we'd like to see you motivated to do something sooner. And I believe there are some other options that aren't as costly, that you might be able to come in compliance with the city code, other than parking it in the backyard, which we don't
Yeah,
want.
I would have done that if I thought you guys would be,
Yeah.
that would work, but.
Okay. All right, well, appreciate it.
Any other questions? There being none, thank you. Mr. Silva,
Please.
can you come up, please? We have
Okay.
one more question.
I just want that on the record, that's all. Well, I just wanted to get that on the record, that you were going to work with him on other options.
I'll get with him, sir.
I appreciate that. I think we can help him out. Thank you.
Okay, there being no other questions, I call for a motion.
I'll take this. Get myself organized here.
Mr. Chair,
Yes.
prior to our going in a motion, just want to clarify, we have a violation against the property owner. I don't know if the property owner's here, but we're going to be basing it on the actions of the tenant. I just want to make sure that everyone's just kind of mindful of that. I mean, we can move
Yes,
forward. It's just an interesting situation here where, and you guys might do this often, but I just kind of wanted to point out, if the tenant does not do what he's supposed to do, it's going to be a lien on the
Right.
property owner's property.
Yeah, and if I may, Mr. Chair.
I noted that also. I was going to say something, but I didn't.
That's why I was hoping to see if there was another option, rather than getting it titled and insurance. I believe you can get an inoperable vehicle tag for a vehicle, and I think that comes into compliance.
Mr. Silva?
Jose has had dialogue with the landlord, so he's aware of this case tonight. Jose, just let him know he's had a dialogue with the owner of the property.
I've had the property manager.
Okay, the name on here is Rebecca Mariana,
That's the owner
the owner of the property.
of the property, and I've had a dialogue with a Miss Lee, who is the
Ms. Lee
property
is the
manager.
property manager.
And
Mr. Lloyd?
are they part of the rental program so that we know they're in compliance as a rental property, so that would help us with any legality?
I don't know right off the top of my
Okay,
head,
all
but
right.
I usually check all my properties.
Perfect, that's what I wanted to hear.
Is
Uh,
Mr. Miller?
The clerk had advised that notice had been proper, so I'm assuming that, the property owner's aware of this, and so you should be able to move forward with an absent violator or absent respondent. Like I said, I just wanted to kind of point that out before we kind of moved forward on
Right.
this, just making everybody aware that, the status of this
And-
case.
And Mr. Silva has talked to the property owner,
No, the
landlady,
property manager.
the manager, property manager.
I spoke to Miss Lee. I've spoken to Miss Lee, who's the property manager,
Okay.
and was aware of the violations that were at the residence.
And just one other thing, I know we've asked Mr. Mueller to look at some other stuff that we do procedurally. Might it be we take this up in unfinished business or new business, look at the rental program contract to see if maybe there's some verbiage in there that would imply that the homeowner, we've got some safeguards there. I don't know if that's you or the city attorney that would look at that.
Be a city attorney.
Okay. All right,
Mr. Lloyd, what I normally do on my properties,
yeah,
if I have a property that I go to a notice on,
yeah,
I always check them, especially if there's a zero on the
Yeah.
exemptions. I always check them to make sure if they're on the rental program. You caught me off guard on this one, so I can't tell you if not, but I usually check them that way, double check them, and that's how I catch them, send them down to our fire risk department.
and that's good that it's on the record that you do that, so it's something that we look forward to and appreciate it.
Yeah, just as far as just a matter of law, I just wanted to be sure that notice is proper before you move forward, so that the property owner had notice of the violation before you make a finding and a lien. But the clerk has advised that
It has
notice has
been.
been proper.
Okay. Proceed with the motion. Thank you, Mr. Silva.
Yes, thanks.
Based on the testimony of Code Compliance Officer Jose Silva and Joshua Cottrell presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find Rebecca Mariana in case number 18-3665 to be guilty of violating section 18-3665, 12-860 of the city code and give the respondents until January 9th to come into compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $30 per day shall begin to accrue on the day following the compliance date and continue to accrue until the date that the violator provides the city with evidence that the property has been brought into compliance.
Second.
Motion seconded by Mr. Pergolarovich. Any discussion? There being none, we'll go for a vote. All in favor? Aye. Opposed? No nays.
Case number 18.
Hold on,
Oh,
please.
sorry.
Mr. Cottrell, there has been a finding and of violation, that the violation does exist. And
No
a
disputing it.
A fine of $30 per day will begin to accrue on January 9th and continue to accrue until the violation has been corrected and gone out. But as I stated in the previous case, that if you're having difficulty meeting this, continue to keep in touch with Mr. Silva and come to the meeting on the 9th and let us know progress. Hopefully, you're all solved, but,
Yeah.
okay?
Yes, thank you.
Thank you. Next case, please.
Case number 18-4204, City versus James and Anna Cunningham Clark, for the property located at 11733 Primrose Lane. The case is before the board based on an alleged violation of Section 8-102-13B, exterior walls maintained in good repair, and Section 8-102-13P, structural supports maintained in good repair. The case will be prosecuted this evening by Officer Laurie Smith. The city has evidence of the notice of violation and notice of hearing were properly served.
Good evening, Mr. Chairman, board members. Laurie Smith, Code Compliance Officer. The case originated proactively September the 27th, 2018. During my inspection, I noted exterior wall staining on the front and side wall, and the structural support columns were deteriorating. At this time, I left a door hanger with a compliance date of October the 19th, 2018. On October the 30th, 2018, I re-inspected the residence and noted exterior wall staining. However, the structural supports did have some repairs but remained out of compliance. A notice of violation was prepared and issued with a compliance date of November the 26th, 2018. No one was home, so I posted the notice at the front door and requested a copy to be posted at City Hall and copies to be mailed, both certified and regular mail, to the address. My inspection on November the 28th, 2018, with Building Inspector Donald Knight, noted structural supports does need a building permit for the additional work. Stop work order was issued December the 3rd, 2018. At this time, I would like to submit photographic evidence of the violation taken by me November 27th, 2018. Exhibit number 1, structural supports need replacement. Exhibit number 2, stained exterior walls.
Board will accept.
Thank you.
Are there any questions of Ms. Smith? Mr. Pilarvich?
Could we get the man behind the curtain to put that beam picture back up? Thank you. My question is are we asking them to get a building permit so that it can be inspected because the work is done, or that we know that what is showing here is while some work was done, it's just, it's not enough.
Yes, sir, it's not enough, and what Mr. Nye is saying, that it does need a permit for the additional work that needs to be,
Okay.
take place.
So, so it's not just a matter of getting a permit to inspect it?
No, sir.
Okay.
From my understanding, when Mr. Clark came in, Mr. Anesi was saying that he needed to get an architectural firm to draw up some drawings, or an
Gotcha.
engineer, possibly to help out with pursuing the repairs for the house.
Okay, thank you.
Yes, sir.
Mr. Snelling?
So, the repairs we're talking about, is that one column that's on the far right? Is that the one with the hole and, looks like a hole in the, or is it the wood beams that are on the foreground?
Oh, there's a really, really bad crack, Mr. Snelling, right there, where Mr. Clark had put the wood to try to hold that section up. That had a really, really bad crack. That was probably one of the worst ones. You can see it in that first picture. Also, the other support columns have big chunks out of the other two, the one on the right as well as the one on the left. That's what's supporting the nominal load of that house on that side, are those support columns.
So it's really supporting the roof.
Right.
Yes, sir, that,
Yes. So that makes it more clear. The first thing when you look at the picture, you look back at that column with the
The hole in it.
with the bumper hole in it, but it's really, it's more important, the structural support, which is carrying the roof.
yes, sir, that's where I believe Mr. Amir said that it needed to have an architectural firm draw up plans for it,
Right.
or an engineer to proceed with the repairs that were needed.
Right, that makes a whole lot more, it's more, a whole lot more obvious
Yes, sir.
that the degree of hazard is increased a whole lot more than when you first look at the picture, you look at that other hole. Mr. Lloyd?
Well, again, I don't know if we need a copy of the stop work order, but do we know, it looks like those beams were replacing the existing structure is completely gone from that roof there. It's not a simple fact as having an architect making sure that that can carry the load and then stuccoing over that. Is that what I'm led to believe?
Yes, sir, I believe so,
Okay.
unless Mr. Clark has.
Okay. Well, I didn't know if it was in the stop work order, what structurally was wrong with it, other than it was just a simple stop work order. Was it the fact that improper material was used? Is it not, where it was concrete block before that was stuccoed over? I don't know.
Well, I believe that Mr. Clark, he came into City Hall on Monday, was submitting some plans and drawings for approval of the structural support system. Building Inspector Amir Anisi would not sign off on them, and stated Mr. Clark needed to contact an architect to draw up the plans necessary for the repairs to be done. Mr. Clark has anything else further to
You had a
say?
question for me?
One last question.
Mr. Poklorovich?
Thank you. Forgive me, I'm trying to figure out how to put this. Is what we're looking at in any kind of imminent danger of failure? Or we don't know? I'm asking the question because, we may be giving them some more time to get the drawings done, but if this thing's gonna fall down tomorrow, that creates a different problem for us.
That I can't address, sir. I'm not a professional in that area. I just.
Did Mr. Amir ever say anything to you that, oh my God, this is gonna fall down tomorrow, or?
No, sir, he didn't. He just
Okay.
would not sign off on the drawings.
Okay.
That was not stated. He just said that he would not sign off on those, and that Mr. Clark needed to consult an architectural firm,
Okay.
engineering firm for.
Thank you.
Just want to follow up to that then.
Mr.
Okay.
Mr. Lloyd?
Is your testimony that is, you're talking about Mr. Anisi, did he in any way give you any impression that this was something that was imminent danger to Mr. Poklorovich? Since you're testifying on him in the stop work order, did he in any way imply that he thought it was merely just a drawing thing that needed to be fixed, or was there a safety hazard there? And maybe Mr. Barone can answer that.
Just to follow up, Donald Knight, the building inspector, went out there with Lori
okay.
and observed this firsthand. So he never said to Lori, we need to declare this as a hazardous condition.
Okay,
So the stop work order was issued because of the condition and the work that the progress here. He needs an architect drawing to continue.
that puts me a little more at ease.
Right.
I'm not a professional here to see that, and wasn't there, and nor can I testify to that, what it is, so thank you for that.
Good job.
Okay, or is that it?
Yes, sir, and as of the date, there's been no change, and the property still remains out of compliance, but Mr. Clark is here, and I'm sure he would like to probably address
Okay,
the board as
thank you,
well.
thank you, Lou.
Yes, sir, thank you.
Mr. Clark? Mrs. Clark, if you're wishing to speak also?
Good evening, how y'all
Name
doing
and
today?
Name and address, please.
11733 Primrose Lane, Tampa, Florida.
Anna and James Clark.
Okay,
Got your name.
James
Thank
Clark.
thank you.
Okay.
Go ahead.
If you notice on that far beam, that one they was looking at, the two with the hole in it, okay, that's where my, the one, the
One
center
on the
one?
side, yeah.
Right.
That's not blocked.
That is not blocked. That is, it got 4x4s in there. It's two 4x4s. And my grandson had to ride a lawnmower and he ran in and knocked the stucco off it. So I just haven't got the time. I was gonna put the stucco back. But when I replaced those, the new beams up there, okay, that was replaced because the old ones had rotted out. So I put the new ones in. And what I did, I secured the structure so I can get those in, put the new posts in, so that I was gonna put, if you notice, I was gonna put new stucco back on that. But now, before I got to it, the one down there with the stucco on it, where I had to take out and replace where it's falling down, that's the one that's coming down. I was in the process of fixing to fix it.
When she says stop.
But on the backside, I already had secured it with some more 4x4s. I don't know if they showed that up there or not, but I got it secured on the backside of that. And I put two more in there on the backside.
There's a lot to look at in that picture. I didn't even see all of this.
Now, on the backside, I took up, that's on the backside of the one that's coming down.
Board will accept.
So I did that to secure the roof, because that, to keep the structure from, keep it steady. So until I can take that out and repair it, so when she told me to stop, so that's where I stopped at. I was in the process of taking and repairing that.
If I may say so, I think what makes it look so bad, when you're looking at that picture where that little chip piece out, I think people think that those columns were block columns. I think that's what you're thinking, but that's just pretty decoration.
They're cased.
So when you
Stuck
put
on
the wood back in, and you get a chance to put the screen back on and put the pretty decoration back, there it is, but
Right.
Yeah.
he put that up there, but when you say stop work, we gotta do what you say do, you know what I'm saying?
Yeah,
'Cause we
what
don't
does-
wanna get in no
Yeah.
trouble.
Right.
And we've been on that property for like almost 30 years, and anything that they ever told us need to stop or need to be done, we take care of it immediately. We don't try to waste time, and we feel like we got so many notices. In a 2-month period, it was just like, what happened to the man that used to come? You come and tell me to do something, and before I could get it done, I got another note. And before I can get that done, I got another note. The other people told me to put the trash side the road. I put the trash side the road, and I got 2 notes about the trash that they said they was coming to pick up, so they lost communication. So it's to the point now where we felt like we kind of getting railroaded down. And I know my husband went to school for blueprints and architect, and he can build just about anything. So we wouldn't be living in no house that's dangerous.
Yeah.
But I think when she took those pictures by her being a female, she didn't understand that those are not block. That's just the pretty.
Yeah,
To make
that's
those, you see the ugly boards that's up there now? That's just to make them hold a part of that roof And then when you put the stucco back on, it's gonna be pretty like the other column did. So,
But I think the whole thing is, like you say, I went to school for architects, so I know about structure. I did a lot of construction work myself, so that's why I knows how to, you know, keep the structure up until I can do what I need to do, you know. But when I went down here, he said I needed to have an engineer and approval, and I need to get a architect to draw. If I know they need all that, I could've took my time and went on and draw the render, you know, of what needed to be done. You know, I thought that you need to show what I needed to do. He said, show what you need to be done. So I just draw my wrist a little rough sketch on the paper and brought it up. And then when I went back, she said, no, that ain't gonna work.
Yeah.
Oh, well, you know, hey, you know, so if I know that, then I could've did that.
Yeah, well, now you know,
Now we
but.
know.
Now I know.
But it is a load-bearing wall, so there is design that needs to be done to carry the weight. And it's possible that what you have, the direction you're going is the right direction. That isn't really the argument. The issue is that you need to get a permit, and the
Replace what was
permit
there?
to replace what was there. And the permit requires an architectural sign-off on it, because he's then becoming responsible for the design weight, the carrying weight of the structure that you're replacing. And if he deems that it's adequate, then you're home free. You got the work done and you get your permit. But I didn't realize by looking at the picture, I started over here with that little hole in the,
yeah, and you thought the house was
And-
falling down.
and the further I went to the left, the more structural issues you have. So really, it appears to be necessary, it obviously is necessary that the amount of work involved needs to have a permit, and it needs to have an architectural sign-off on it, whether you could do the plans and they sign off on it, that it still has to be the structural integrity of that beam, which is carrying the front of your house. So,
So even though
All I
that's
did
the
was
same-
replace what was already there. I just replaced it. I mean,
yeah,
it's
but.
nothing no different.
But the amount of work that was done is, and that goes back, it's not
Right.
it goes back to the building department, and it's a requirement of the city. So, once you satisfy the city's need, then you can go ahead and finish the job and get your stucco back on.
Excuse me.
Well,
can I
first she
ask a
told
question?
me that,
How do we determine, I'm just gonna ask you this question, because I don't know a lot of stuff, but you say to satisfy the city, right? So is somebody gonna come and look and see, or should he, like the piece that's off, should he take it on off so the people can see the same lumber that he got is the same lumber that was there? Is that making sense what I'm saying?
Well,
Actually, go ahead.
when you get your plan from the architect and his signature, and you present that to they will review, the building department will review the plan and sign off on it and give you the permit, but there will be an inspector come out to see the rest of the job to final. So,
So we need all of that to replace what was there. So who gonna come?
I got a question for him.
Okay, he has a question. I'm sorry.
And then
The-
Mr. Pogorich had us.
the building inspector will come out after you have your permit to, again, inspect where you are, and then they will make one final. They do it on all, like kitchen remodels, their AC remodels, all of these things have to have a permit.
Oh.
And usually, the contractor for this extent of this work would have had to get a permit for you as well. And he would have had plans. So it isn't just you, it's the process that has to be done. It's for your safety and the community's safety.
well,
You
excuse
have a
me.
question, this one have a
Oh,
question.
go ahead. Yeah, go ahead.
The reason why they want a permit is, and the reason why it's gonna get inspected, is they want to make sure the work you're doing is brought up to current building codes. And no one's questioning your experience or anything like that.
Yeah.
But codes change every,
Oh,
you know,
yeah.
4 to 8 years, and, I mean, just looking at that, I mean, there's things there that I know that need to be updated. And, so, I mean, that's the reason for the permit and the inspections and the prints and everything, is to make sure that we're doing it up to today's standards.
Right.
I do. Something to-
Mr. Lloyd?
Our goal here is to try to help, determine a resolution to this. I don't know that we would be able to speak to some of the questions you asked as far as how many inspections and what they would do in that respect. I will tell you that both Chairman, I can't forget, Schmidt and Mr. Westfall have brought up good points, that it is for your safety. Given you're physically able to do the work, but the architectural part to meet the code, how much time do you think it would be to get that taken care of for you? Because I see you can do the work, but to get that architectural drawing signed off, how much time do you think you need to get that looked at?
Do you know who the architect person is?
First, I have to go, first I'm gonna have to get an architect, I can't
Okay.
draw it myself, so,
Okay.
Well, you
I
can
mean,
draw
I
it,
can
but
draw
he
it,
have to
but-
sign it off, he said.
oh, I can draw it myself?
I don't know. That's what you're gonna get with.
It's up to the architect.
You get with get with Code Inspector Lori there,
Okay.
and so forth, and then meet with community development. I've worked with Mr. Anisi, not on this board, but as a citizen, working on my house, so I do know that the permits need to be pulled and so forth. And he's very good about telling you what you need to do and the next steps.
Okay.
That's one thing, the city of Terrace, compared to some other municipalities, they will walk you through that process.
Okay.
Is it something that you're gonna be able to tackle over the holidays right now? Because, you're going into the end of the year and the new year. I mean, generally, we give 30 days for this kind of stuff. Do you think you're gonna be able to try to get this done in 30 days?
No, because
Okay.
I ain't gonna tell you that.
I'd rather be honest to
Yeah,
us,
I'm not gonna put myself on
So
that
you
kind of
just tell us
stress.
how much time
Okay.
you're gonna give us.
All right. Because, like you said, you've done most of the work, and it looks like you're very capable, so,
Yeah.
I mean, we can make a recommendation to you there that now that you've made that statement, but we'll consider that. I just wanted to see if you were equipped to do it within 30 days. And it sounds like you still need to source an architect and somebody to sign the drawings, or an engineer, I should say. Okay.
But I'd like to say something. When I first went up there, a young lady told me I didn't need because I was a resident, I didn't need no drawings, no architect or nothing. She just told me, because I told her what I was doing. She said, "What you doing?" I said, "Well, I'm replacing some existing posters that's already been rotted out, and, some is already put back." She said I didn't need none. So if you notice on the application I did, I checked resident, because she said you was resident.
Right.
So you don't need no architect and nothing like that. So see, that throws me off there too.
Go ahead.
I think the difference here is, once the inspector came out and found out it was load-bearing,
Right.
that changes the story
Right.
dramatically. And just so you understand, the process here is going to be that you find an architect, and I imagine Amir or somebody can give you some names of who to talk to. They give you a set of drawings, you take the set of drawings back, you get a permit. You go do the work, and they will tell you what you can do and when they want to inspect it. It gets inspected, and then it's done. And then obviously, that's not gonna happen in 30 days. It's probably not gonna happen in 60 days.
Nope.
So, we're probably looking somewhere in the neighborhood of 90 days minimum
That would be close. That would
to,
be good.
to get all that work done.
Yeah.
Between, architects also take vacations around the holidays too, I think.
Yeah.
So I think that's probably what we're looking at, but that's the process. And, when you tell somebody you're gonna come in and replace a post, that's different than going out there and doing what you're actually doing. And that's just, you saw it as replacing a post, but it's holding up your roof. Okay, that changes the entire story. It makes everything different. And they've all said it, and I'll say it too. We're not here to punish you, okay? It's for your safety and for the safety of whoever buys your house after you decide to move on, or you sell it or whatever. We want to just make sure that whoever's in that house, forever long they're in that house, that they're residing in a safe dwelling. So,
We appreciate that. So how much time you giving us now?
Okay.
Since that man said it's gonna take us about 90 days.
Well,
We'll
That's-
make a motion and see what we
we will
Y'all make
make
some
a,
good motions now. We ain't no spring chickens no more.
We will,
We done quit springing, we ain't chickens no more, so give us a little bit of time.
We
do it all
want to make sure
perfection.
that grandson's not going to hit your new work too now,
You got
so and
that
it's
right.
put up right, so, you know.
He over there at the Boone cooking, I'm gonna keep him over there, cause he done screwed me up already, got this lady think my house falling down, what?
okay, I'm going to be calling for a motion here shortly.
Okay.
But before I do that, I want to just say that it's not a normal thing for us to go out 90 days. And so if the motion, just preparing you now so you don't drop on the floor, because I have to run over there and catch you. and I'm not that
Better catch
fast.
me quick too, cause I'm easy to fall.
But anyway, what the motion may be for 30 days. And as I said in the two previous cases, that you would come and let us know what your progress is and that you're moving on it. And if you come back in 60 days and you got your architect and you're almost there, and it may be 90 days, but the motion may be for 90, I don't know. But I
Don't
just
be
want
mad,
to
'cause
prepare
gonna
you.
retire before 60. I can't have you leaving now before my job get done. No retiring.
I'll be here,
Okay,
one way or another.
Yeah.
all right.
But anyway, I just want to let you know, so you don't get perturbed or
Pass out. or
pass out. Yeah.
something. I promise.
All right,
I hold on.
all right. Thank you, and you may be seated.
Okay,
Thank
we
you.
thank you all, you know.
Okay, call for a motion, please. There being no other persons in the room wishing to speak on that, so,
Do we need to get that evidence that was presented by them? Does the city need to review it, or?
they've given it back, I
Okay,
think.
they gave it back to them, we don't need it in evidence. Okay, I just wanted, it was presented to us and we looked at it.
We'll keep it.
Do we want to, do you want to,
Mr. Moore?
Ms. Ross?
It's part of the record.
Yeah, okay.
okay. A motion, anyone?
I'll make a motion.
Mr. Lloyd?
Based on the testimony of Code Compliance Officer Lori Smith and Mr. James and Anna Clark, presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find Mr. James and Anna Clark in case number 18-4204 to be guilty of violating section, where's my sheet here? Here we go. 8-102 subsection 13 subsection B and 8-102 subsection 13 subsection P of the city code, and give the respondents until February 13th, 2019 to come into compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $50 per day shall begin to accrue on the day following and continue to accrue until the date the violator provides the city with evidence that the property's been brought into compliance.
I second.
I have a motion, second by Mr. Westfall. Any discussion? I think that the.
I'll be happy to.
No, I agree with the 60 days.
I
And then
agree
having
too.
them come back at 60.
Couple.
If we can't get it done,
Couple of things, there's two different sections of the code in violation, and so that's why I'm giving them the extra time, and because of the permitting needed, I'd like to know when they come back that process has already been started. And then they can ask for an extension or whatever else, and who knows, the permit might in itself enact an extension, I don't know. So I won't know that until we see that, so, okay,
Go ahead and get your architect and get going.
want to have a vote there?
Yes. Any other discussion?
no.
All in favor?
Aye.
Opposed? No nays. So, as I was saying, go ahead and get your architect and get on it and return to us on the February 13th, and unless it's all resolved, and let us know how you're doing.
I just want to say, maybe encourage them to communicate with Code Compliance Officer Smith and,
Yes.
and make sure that they stand.
Well, they will be following up with her because of their, through the city, so,
Awesome.
okay, thank you. Next case, please.
Case number 18-4372.
Thank
Merry
you.
Christmas.
18-4372, City versus Robert H. Treat for the property located at 8630 Cattail Drive. The case is before the board based on an alleged violation of Section 12-860, inoperative vehicles, outdoor storage equipment. The case will be prosecuted this evening by Officer Jose Silva. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, board members. Jose Silva, Code Compliance Officer. This case originated October 5th, 2018, proactively. During my inspection, I observed a vehicle parked in the visitor space across from the residence with an expired tag. This time I opened the case. Inspection on October 16th, 2018 revealed no change. Notice of violation was completed with a compliance date of October 27, 2018. No one was home, so I posted a notice at the home as well as City Hall. Also mailed copies, both certified and regular mail, to the address of the registered owner. On October 29th, 2018, I was contacted by Mr. Treat, who is the owner of the residence, who advised the tenant remove the vehicle from the property. I re-inspected the location on October 30th, 2018, and noted the vehicle had been removed from the location, at which time I brought the property into compliance. On November 15th, 2018, while conducting inspections within the complex, I located the same inoperative vehicle parked a block away from the original location in the visitor's parking spot. Since it was within the 45 days of notice, I set it for the MCEB hearing. This time, I'd like to submit photographic evidence of the violations taken by me on October 16th and November 15th. Photograph number 1 is going to show the posting at the front of the notice at the front door on October 16th, and photograph number 2 and 3, taken on November 15th, it's going to show the inoperative vehicle with the expired tag parked in the visitor parking spot.
Board will accept.
As of today's date, I conducted another inspection at the location, and the vehicle has been removed from that property. I'd like to submit an affidavit of compliance.
Board will accept.
This time, the city's asking for a finding.
Okay. Mr. Treat is in.
I believe Mr. Treat's right here.
Any questions, Mr. Silva? Thank you. Mr. Treat? Welcome. Name and address, please.
Thank you. The name is Robert Treat. I live at 514 Royal Greens Drive here in Temple Terrace. I own the property on Cattail Drive. This is a rental property. I've lived in Temple Terrace 40 years. I've had rental property in Temple Terrace for 40 years. And this is the first time that I've been called to a hearing on any of the rental properties that I've had. Because of my age, I'm getting out from under that. This is the last rental property that I have, and I hope to have this one sold in 2019. This particular violation, I talked with the tenant, Jose De Jesus, and told him that the car had to be removed, and it was removed by the 25th of October. However, I did not know the information that was just given that in November 15th, they found the car back in that area. I'm sorry that I wasn't notified of that, because I would have taken action myself on that. As I understand it, now that we have the affidavit of compliance, so that exonerates the entire case, and you're no longer concerned about me or the tenant. So it's over and done with, right?
That's.
Okay. Jose would have been over here tonight, but he's a diabetic and he had dialysis tonight. And he tried to get that changed and he couldn't get that changed. So I said, okay, I'll handle it. So I'll call him, and I assume the city will also send a notice or let him know. Is that how that's handled?
Mr. Treat,
Let the tenant know?
Mr. Treat, what is going to go on here is you are the one you're the property owner,
That's correct.
so you will be notified of what went on here tonight or what is going to go on here tonight. And then you will, you can let him know if you find that you want to know.
Okay.
They won't, because you're the address of record
Okay,
and the owner of the property.
okay, so then I let him know.
That's why you're here tonight, because you're the owner of the property,
Okay,
and he would
Well-
just be your tenant. And the city, because of the address of the residence, I believe that was the residence.
Cattail is the
Yeah,
residence.
so he will get a copy of it.
He'll get a copy also.
I believe so. That's up to the city staff to do that, but as far as I know, Mr. Barone, can you answer that question definitive?
I'm sorry, I didn't hear the question.
The question is, will the tenant be noticed as well?
No, the landlord's required to let the tenant know the finding of the case. The only thing I would tell him is that if it happens again, it's a repeat violation, and that's where he should be aware of the landlord, because we go after the property owner,
Okay,
not the tenant.
okay.
I do want to know these things. I have tried to provide good rental property for all of my tenants over the years, and I do try to keep track of these things. So if these things happen, I do want to be notified so that I'm aware of what's going on. In this respect, I will say that it seems a little bit strange to me that this is an automobile registered in his name, which was not parked on my property. It's his personal effect, and it seems like I'm the one that's responsible for it. That I don't quite understand why. If it was something inside the property I owned, or on the property I owned, I could see where you come to me and say, okay, you've got this problem and you gotta take care of it. But as with an automobile, it's his personal effects, and you're asking me to take care of his personal effects. So I don't quite understand why I get in on this thing.
Well, you're the owner of the property, and the vehicle was parked on your property, so the property is cited
Well, but
because
it
of the
wasn't
violation on the
parked on my
property.
property.
It was initially.
It was parked in the Meadowwood complex, but not on my property.
That was in November. The original one, I believe, Mr. Silva, clarification?
I can clarify, sir. I originally dealt with this vehicle in April of this year, when the vehicle was originally parked in the carport to his unit. That point, I did a notice of violation. The vehicle at that point was moved out of the carport, and the property was brought into compliance. When I came through the complex in October, it was parked across the street from the unit. I knew it belonged to the unit that was being rented, which was his tenant. That's how I generated this notice of violation. It was tied into that unit, so that's how we got to this point.
Okay, Mr. Treat, do you understand how the connection is now to the property, to you? Because you're the owner of the property, so that is how this case came to you and why you're here tonight.
Okay, but why I'm questioning is, yes, I own the property, but I don't own this property. It's a car registered in his name, so it seems to me that it should have been dealt with him directly. He takes care of that problem. If it was something that involved my property, then I could understand it.
Well, it
Why don't we let
does.
the attorney, maybe he can help out here.
Can I ask a couple
Sure.
of questions?
Sure.
Sure, please.
Is this, I'm not familiar with this property, is it like a?
This is a condominium complex, right.
And the parking lot that this was parked in, is that is where it was parked initially your property, that parking spot, or is that? more of a-
Initially, it was
Or the
parked-
condo association's property?
Initially, it was parked in the carport, which would be my property.
Okay, it doesn't belong to the parking lot doesn't belong to the condo association, that is not common property?
I don't think that the carport, I think that's part of the unit that I own.
My recommendation on this one, before you move forward with any type of lien, is perhaps ask the city attorney to investigate the car, being parked in the parking lot and what the legality of that is with regard to what your code requires.
Well, there is no, it was a finding, but there is no lien on this. There is no lien. It's in compliance at this date.
I understand, but you have the legal implication that if someone else parks a vehicle, the same type of violation in that carport or in that lot, again, Mr. Treat will be the one that has the repeat violation. I would just ask that maybe the city attorney should take a look at this case prior to finding and just continue it for 30 days. That would be my recommendation.
Mr. Lloyd?
Mr. Treat, we're talking about this because even though it's compliant, if it happens again, the
Right.
fine would start immediate. You
Yeah, I
wouldn't have
understand that.
you wouldn't have days to cure it. So that's why we're wanting to make sure this is vetted, not let you think that if it happens again, you go through the process of having so many days, the fine would start accruing immediately. So that's why we're having these discussions. Mr. West, Mr. Chair.
Mr. Westphal?
And my question is, this is a condominium, it's not considered a townhome?
It's a condominium.
It's a condominium,
Yeah.
okay. Because my understanding is there's different code requirements for condominiums and townhomes.
Yeah.
So, I think, yeah.
Now, in reference to Mr. Lloyd, to what you just said, my understanding is that if it occurred again, and I'm reading off the paper here, it was corrected and reoccurred within 45 days of this notice, case may be presented to the Municipal Code Enforcement Board, even if the violation has been corrected prior to the board hearing. So you'd have 45 days in there.
Well,
Yes.
that is one component, but there is another component that the city has called a repeat violation that is not, that is outside that 45 days.
Okay.
And that's where the concern is, if we find you today and we say, find that judgment today for you, then the next time there's a violation, the clock starts immediately. And that might be,
Yeah.
another tenant,
Okay.
and so we want to make sure before we enact on that compliance certification from the city, that we're indeed doing the right thing.
Yeah, okay, well, I will explain
Okay.
that to the tenant also, that if he
Right.
brings his car back in, then he's immediately in trouble, and it isn't, get any break on that.
That would be
And
great.
the other question I have is, we're not, I think there's 22 code books for the state of Florida. We're not in violation of any of the laws of the state of Florida. These are regulations for Temple Terrace, right? Am I correct there?
That's correct.
Yeah, okay. Well, I thank you all. I'm happy if you're happy.
I have a question for Tom, but while you're there, just, you might want to rebut, but being we're in compliance tonight.
Right.
Now, I just want to make that statement first. And the tenant's car, which was in the carport area, was the one that was found to be a violation. But when this case goes through, if it's been suggested that we continue it for 30 days for the city to figure out how that property is, and I'll ask Mr. Mueller to restate that. But my question, and I think it was unclear to Mr. Tate, that the tenant's car was there with an expired tag. Any other car that was sitting in his carport with an expired tag and found as a violation would be
Considered a repeat
considered a
violation.
repeat violation.
Within 5 years.
Yeah.
Yes,
40, within
within 5
5
years,
5 years.
right,
That's a long time.
yes. But an affidavit of compliance has been submitted, so we're just looking for a finding.
That's
Says
correct.
won't be no lien,
That's
no
correct.
30 days, okay.
I think the
Mr.
concern is if there's a repeat violation. So my suggestion would be that we do the finding tonight, and find that it's in compliance.
Right.
We meet again next month. If somebody were to park there tomorrow, we're not gonna deal with it till next month anyway.
That's correct.
So that gives in-house counsel plenty of
Yes.
time to research that and see whether or not we need it to.
I have a
And
question.
I just want to, knowing the owner's testimony tonight, if this was to occur tomorrow or next week, we will reach out to Mr. Treat, and I'm sure he'll take care of it.
But, just real quick,
Mr. Lloyd.
to our attorney, as a point of order, if we find in compliance, then, and we accept that affidavit, then that enacts the repeat violation, does it not? And if we don't accept the affidavit of compliance and extend, and have the city look at it, then he would not have that, for lack of a better word, the sort of Damocles repeat violation hanging over his head.
I thought they were looking for a finding of guilt also. I may be
Yes.
incorrect on that.
Yes.
Then
they are.
there is, to me, there's gonna be an issue there. I'm a little concerned about
Okay.
that decision, because what it seems to me, if I understood the testimony, and I'm not trying to get too involved in this, but I thought what triggered it bringing to the board here and for a finding was that the car was actually in a visitor spot, which I am going to guess is not Mr. Treat's property. And I just really want to be careful when you're making a finding of violation. That's why I would like for the city attorney to investigate that in light of what the code requires and what the ownership of that parking lot is at that condominium.
Really quickly, if
Mr.
you
Huber.
didn't know that that vehicle belonged to the tenant,
Right.
who would you have sent the notice to?
We would do a plate check, and we would try to run the tag, find out the ownership where they reside at.
Okay. Would you have, now, if it is common property for Meadow Point or wherever the HOA is, would you, say it wasn't even someone who lived there?
We would go after the property owner, which would be the condo association.
Okay.
But we also try to get the police involved because it is an expired registration. But technically by law, they have to be driving the vehicle for the police to pull them over.
So just to clarify, if you weren't aware where that car originally resided when you fired the first time.
Right.
You would run the tag and find out it belongs there anyway.
That's correct.
And the same, we'd be right back here at the same place, doing the same thing.
Probably, yes, sir.
Let me just add this comment to further complicate things. You said that the car was parked in a visitor's parking area, but there are actually no visitor parking areas designated in that condominium complex.
Oh, so we can get on record what you're saying.
Oh, okay. Just to complicate things one step further, you say that the car was parked in a visitor's parking space, but there are no visitor parking spaces marked in that condominium complex. Now, I don't know how.
And again, I might have misunderstood Officer Silva. I thought but I might have misunderstood what Officer Silva said.
No, he said visitor spot, but,
Do you want to comment?
yeah,
Do you want to
yeah,
comment?
Okay.
yeah.
Do you want to comment?
But I think the point here is that whether he was parked, wherever he was parked, whether, if they didn't know, they would have ran the tag and it would have got him right back to the same spot we're at tonight. So again, I would suggest that we do the finding. We can have the city's in-house counsel do some research by next meeting. It's not gonna make a hill of beans of difference because, like I said, the procedure is, if they don't know, they find out. And it would have gone back to that particular ownership anyway.
See, I disagree.
Well, I have a question.
My other recommendation to the board would be just not to make a finding and just don't approve it. Just say that there's lack of evidence and you're just not happy with the testimony or I mean, this is not gonna happen again, I'm sure the way the
Well, I-
gentleman's. this is
I
the way-
feel that
So if
same
the-
way.
if the board would feel more comfortable, then I would just pull back the case and just,
I have a, yeah, I
Just
have a
let it go.
question for the attorney when you have a moment.
I have a question for Mr. Tate.
Treat.
Treat. When, as the owner of the condominium, and in a lot of condominium and townhouse locations, there are additional parking places for you. You have one, and there may be another one somewhere on the property that is assigned to you if you have someone come to visit you, and that's where they would park. So one parking spot is kind of assigned to you, not that it's your property. And that's not where I'm going. I'm not arguing this whole thing all over again. But is that something that you're aware of?
This is an interesting point that you brought up, because since I got the violation, I've thought about this. There actually is no designation that this carport parking space is for me. So I'm thinking anybody could park in that carport, although I wouldn't like it. If I lived there, I'd want to put my car in that carport, but I don't see anything that tells them not to do that. And there are other parking spaces outside the carport, so especially in a husband and wife deal where they have two cars, one car is parked outside the carport in some of the other spaces. Yeah. The other thing I need to ask is, my tenant, Jose De Jesus, expects to get this car back on the road, and I'm assuming he will be bringing it back in, and he needs to get it repaired, and he's another one of these people who always has a shortage of money, so it may take him a while. But he will be bringing it back into the compound, and I assume he'll do that with plates on it and the
Yes,
car in running condition. So then I assume it's
not a
gonna be
problem.
okay.
Yeah, it's not a problem, because
Yeah.
it's now.
Okay, all right.
I have a question for the city attorney.
Okay, go ahead.
Can we make a finding of the property's brought in compliance with no guilt?
No, because it was a violation, we just heard a violation.
It's still,
Because of the.
I'm inclined to think that if you're gonna find it that it's well, my guess would be you could say that it's a little complicated, because the fact that you're finding it in compliance, but in and of itself is going to make you say that there was a violation at one time. So I think I think what the code supervisor had suggested is you're either gonna find it in violation, or you're gonna find that there was no violation.
And based off of what you've brought up has led me to believe that maybe we should be hesitant to make finding a certain way. Is that what I'm led to believe?
I am concerned about you entering an order when there may not,
Okay.
if this was if the vehicle was found on property that Mr. Treat did not own. It's different than like if it's a single residence, single-family residence where it's in the driveway, or, what we've seen here before, where it's actually on the property of the property owner.
What I'm
Here,
trying-
he
yeah.
owns I believe, a condominium unit,
Right.
and not necessarily
So,
the parking lot. And
okay.
that's where my concern is.
I'm trying to connect the dots between what Officer Barone said and what you're saying. So if I were to make a motion, the motion, based off what I'm hearing from you and him, is that we feel there's not enough evidence for this case to move forward as far as what we found. Is that correct, Mr. Barone?
yes.
Okay, and then if it comes up again, they'll open a new case and so forth and bring it to us in violation.
And it would be seen as a case of first impression. The first one would not be a repeat violation.
Right, okay.
Mr. Newkirk?
Yes, I just wanted to say that, Mr. Treat, this parking place, the second parking place, that was part of the condominium property, wasn't it?
That's right, that's part of the.
All right, that, to me, that answers all the questions everybody's been going back and forth here. That's why it was cited the second time, 'cause it's still part of the condominium.
Well-
Might not be the condominium he owns, but he pays dues every year or every month, however they do it, I'm not sure. Homeowners dues for these other parking lots and everything, for the upkeep and everything. So, that being the case, there's no question here, it was in violation because it was parked in a parking lot that was, part of the condominium. It wasn't on the side of the street, you think, it's a condominium. Maybe not his unit, but it started with his unit, and then when it's moved over to the, parking lot it was in, that's still part of the condominium. So, here, he was guilty of, whatever the charge was right now, and then it's been brought into compliance, case closed.
Well,
And there's no repeat or anything.
that parking space is called, the common area. It's part of the common
Yeah, well,
area.
that's what I was talking about, in that common area, though.
So that's owned by
That's
the-
part of the condominium complex.
Right, it's owned
So
by the
that's why they
complex.
noticed it that way.
Pardon me?
That's why they noticed it, because it was a common area. If it was over in the, public street, they couldn't be nothing
Right.
done. But it was in
That's
part of
not
the
true.
common area of the,
Yeah.
condominium, which you pay dues on to have the lawn mowed and everything else, have the upkeep. Homeowners dues.
Mr. Pavlovich.
Mr. Barone,
Yes,
if that car was in my driveway,
right.
who would you cite?
You, sir.
Me?
Yes.
Okay,
As long as you're the owner of that property, we would be citing you, sir.
okay, so, but if you ran the tag, if you ran the tag and it had some other address,
We would still be citing you, sir.
okay, what if it was parked in the street somewhere?
We would run the tag to make sure that you're the owner of that vehicle. And if it is, we would be citing you, sir.
Okay, but if it was parked in the street outside of my house,
Right.
and you, you know, just sitting in the street, you would run the tag and you would find out he lives somewhere else, you would go cite that somewhere else.
Yeah, well, no, we wouldn't do that. We would probably call the police,
Mm-hmm.
or we'd probably just let it go.
Okay,
Or would you cite him, let's say it's, the vehicle sitting in his house for 3 days, you would cite the homeowner in which the car's sitting in front of, would
Right.
you not?
so I think it goes back to, it was, I still think that we can find a notice of violation and give the city attorney the month to come back and say, well, if it happens again. I mean, you can always, even if it comes back as a repeat violation, this board doesn't have to fine anybody. They take the circumstances for each case into account.
Right.
And, I just think it's cleaner, let's just put, it's probably not gonna happen again. He's not gonna let it happen again.
Right.
So I think it'd just be cleaner to just go ahead and read the notice. That still gives in-house counsel a month to do some research on this particular nuance. And if it comes up as a repeat violation, this particular board has the power to say yea or nay.
Thank you.
And is that, sorry, I just wanted to follow up on him, Mr. Pavlovich,
Mr. Lloyd?
And that we don't have to take into precedence the repeat violation component that we've enacted over in the past few years, because that's new to the city. We don't have to take any precedence into consideration when we hear those cases.
Each case is itself.
Each
Okay.
case stands on its own, each case has its own set of facts, and, you're not robots. You have the ability to think and process and come up with your own decisions, as long as there's some logic to it, and you've taken into account the unique situation of every case. I would stand behind every single decision.
Okay, because we've had homeowners that have repeat violations, and we do take into consideration the precedents is set on repeat violations. So that's why I'm kind of finding that's a little contrary to what we've done previously. And that would be something that the citizens were saying tonight. Well, it doesn't matter if I'm cited and get repeat violations.
I'm not-
And I just want a little clarity on that, because it's a different way of thinking than I've been.
I'm one person. It's up to this
Yeah,
board to make a
sure.
decision. But I'm telling you that, part of our job is to take into account the unique situation that comes before us, the unique set of facts that come before us, and to make a decision based on those unique set of facts. And precedent certainly is part of it. I mean, if you have two cases that are exactly the same, you're not gonna find one person $100 a day and another person $10 a day. But this case, I think, fact that we've been talking about it for an hour and a half presents that it's a unique set of facts and should be treated as such.
And in closing, I would just say, I think it would be remiss as someone that was very vocal about getting a sitting attorney on our board to ignore the recommendation of our board attorney.
Any other comments? Call for a motion.
Okay, I'll make one. Find my little paper here. Forgive me since it's my first reading. Based on the testimony of Officer, it's been so long, I can't remember who presented it. Officer Silva, as well as Mr. Treat, presented to the board this hearing and the documented evidence received by the board. I make the motion that the board find, oh, it's in compliance, yeah, you're right, I'm sorry. Present to the board this documented evidence, present to the board. I make a motion that the board find Mr. Treat in case number 18-4372 to be guilty of violating sections 12-860 inoperative vehicles of the city, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
And I'll second that.
A second by Mr. Newkirk. Any further discussion?
Yeah, I'll just say, I'm not comfortable finding him guilty in this situation at all. The car was parked, anyway, I don't want to go through that whole business. I'm not going to support the motion.
Yeah, and
Well, we just do the vote?
yeah, I'm not, I mean, the fact that I don't quite understand the definition of what a condominium is, compared to a townhome or residential home, I just don't feel comfortable. I don't know if he owns the lot or if the association owns the lot. I'm just,
The association is owned by the condominium people because they gotta pay to keep it up.
I understand, so I wonder if the association should be here this evening.
Well,
As-
No.
Yeah, all right.
I'm,
The owner does it because when he buys, he has to pay his condominium dues.
As
Or
someone,
townhome dues, it don't care which one.
But he, as a condo, he only owns the space within the walls of the condo. As a townhome, they own the exterior building, the siding, typically the parking lot, the
it's
parking
part of,
spot, so.
it would probably then fall in as part of the amenities.
Yes.
Yeah, and I'm just, I don't know.
as someone that's,
Comparing it to a public street, there's no comparison. That's a public
Yeah.
street. This here's a common area for the condominium people or townhomes.
as someone that spoke in front of Mr. Poglorovich when he's on city council, as well as city council, about getting the city attorney, I think we fought long and hard to get this, our board attorney, I should say, and I think we should take the advice of that. That's all.
Well, I'm opposed to your opposing, so
Let's take a vote.
I'm just stating my position. Everyone else has had a chance,
Yes,
so.
Newkirk,
But I support Mr. Poglorovich's motion and the second. And I think that we've beaten this horse pretty much till the end. And we've all learned some things, and I don't think it's harmful to vote for this. If it does, we'll deal with it at that particular time. So, any other comments? Call for a vote. All in favor? Aye.
Aye.
Opposed? Nay.
Nays.
Hey,
Nay for Mr. Lloyd, Mr. Westfall, and Mr. Snelling. Motion carries. Next case, please.
Case number 18-4455, City versus Curtis D. Gay, for the property located at 12305 North 53rd Street. The case is before the board based on an alleged violation of Section 8-102-13B, exterior walls maintained in good repair. The case will be prosecuted this evening by Officer Lori Smith. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, board members. Lori Smith, Code Compliance Officer. The case originated proactively October the 10th, 2018. My inspection revealed the exterior front wall of the residence is stained. At that time, I left a door hanger with a compliance date of October the 18th, 2018. My inspection on October the 30th, 2018 revealed no change. Therefore, a notice of violation was issued with a compliance date of November 10th, 2018. I posted the notice at the property line due to the no trespassing sign, and I also requested copies to be mailed certified and first class. Also requested a copy to be posted at City Hall for the 10-day requirement. My inspection on November the 27th, 2018 revealed no change. At this time, I would like to submit photographic evidence of the violation taken by me November the 27th, 2018, Exhibit 1, standing on the front exterior wall. Exhibit number 2, posting the notice of the violation at the property line.
Board will accept.
Thank you, sir.
Thank you.
Continue.
As of this date, sir, there has been no change, and therefore the property remains out of compliance.
Okay, and you're looking for
Yes,
a
sir.
finding.
Yes, sir. Looking for a finding.
Any questions? Of Ms. Smith?
I'll wait.
Do you have a que- The, okay.
Yes, sir.
The Mr. Curtis Gay? Mrs. Curtis Gay? Hi there, Mrs. Gay.
Curtis Dolores Gay. I live at 12305 North 53rd Street, Temple Terrace.
Your first name Curtis?
Yes, sir.
I'm sorry.
Named after my grandfather.
I'm
Born
sorry.
on his birthday.
It's my first time.
That's okay.
Please go ahead.
I had my grandson to finally get a pressure washer, and he pressure washed the walls at the front, and he painted the front door. And I think those are the two things that she wanted done.
Okay. It is still out of compliance?
She said she looked at it today.
Miss Lori, Miss Smith,
As of this date, yes, sir, it was, when I looked at it.
come on up, please.
Yes, sir, as of this date, it was out of compliance. I don't know what time that you did the pressure washing, but
He did it all afternoon.
I came this morning, ma'am, it was pretty.
What about the wall? I mean, the door?
The door was already taken care of. The
Okay.
grass you guys had taken care of as
Right.
well. That was part of the original violation. You guys came into compliance with the
Right.
grass, and you also got the door painted.
Right.
The only thing what left, ma'am, was just all that staining that was all in the front.
Well, I've got pictures, but I don't have individual pictures.
Okay, okay. Lori,
Yes, sir.
I think what we're talking about here is that the work that was continued on today, and they may indeed be complete, on your next rounds through there, you'll see. So if there's well, that's a difficult one. So if there's a finding tonight, she would have 30 days to bring it into compliance, so that would be fine. And if it's already done on your next view, it would be in compliance.
Yes, sir.
Okay. Does that help you, ma'am?
Yes, sir.
Okay. Mr. Barone.
Ma'am, do you have a picture of your photo today?
On my phone?
Yes, could I see that, please?
Sure.
Lori, what time did you go by today?
It was this morning early, sir,
What time?
I mean, I probably 8,
Okay.
9.
So, sir, what time did you pressure wash the wall? Okay, that's,
Yeah.
our inspection at 8 o'clock this
Was
morning.
before.
He pressure washed at 11 o'clock. That's why
I
we
came by
still,
way before.
Okay.
I didn't even see the pressure washer when I came by.
okay,
It wasn't out there when I came.
Oh, wrong way.
okay. So it's.
So is your judgment then that, well, even if it was 30 days, it would be in compliance, but if, in your judgment, would it be in compliance today?
No, it's in compliance, but the inspector went out at 8 AM this morning. He pressure washed the wall at 11 o'clock this morning. That's after the inspection. So that's why she's saying it was out of compliance.
Okay,
On the notice of violation, it's supposed to be corrected prior to today's date.
right.
So technically, they are out of compliance, but we're willing to submit, based on the pictures from the phone,
Okay,
put the property in compliance, and we will submit an affidavit of compliance.
very good.
Okay?
Thank you.
Laura, you okay with that? Okay.
And you want no finding on this at all?
Well, we're
It's
looking
in
for a finding now.
compliance.
Yeah, okay.
Yes,
Okay. I just want to
Yes.
make sure there wasn't
Compliance,
being
so.
dismissed. Okay.
okay.
All right.
So we'll submit an affidavit of compliance
Yes.
tomorrow
Yeah.
morning.
Okay,
Awesome.
Okay?
Okay.
It's cleared up?
Yes, that's
Okay.
fine.
Thank you.
Perfect.
Thank you.
thank you, Curtis.
Thank you.
It's all you.
I'll do it.
Call for a motion.
Let's get her moving along. Based on the testimony of Code Compliance Officer Smith, Code Director Baroni, and Ms. Curtis Gay, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find Ms. Curtis D. Gay in case number 18-445 to be guilty of violating section 8-102 subsection 13 subsection B of the city code. But because of the testimony of Code Director Baroni, the property was brought into compliance before this date of this hearing, and no fine shall be assessed.
I'll second that.
Second by Mr. Newkirk.
Just a point of order, I heard case 18445, the actual
Five,
case
oh.
number is
455.
184455.
Apologize there, I left one number off, so to clarify that motion, it's case 18-4455. If it's advised that I reread the whole motion, I'll be happy to.
I think you're good.
Good, thank you for catching that.
Second. Any discussion? All in favor?
Aye.
Opposed? No nays. We're going now to the lien reduction, which is on page 5. Well, it's my page 5.
I don't do the case number and stuff like that, but it's okay. It's okay. It's okay. I got it.
There's two, Mr. Chairman.
Right,
Are they separate or combined?
okay. I'll try to, I'll go slow on this one. This one's difficult. There's a lot of cases involved. But good evening, Tom Baroni, Code Compliance Director. At this time, I would like to introduce these lien reduction petitions requests in case number 060840, 13-1787, 14-1820, 14-2840, 15-1476, and 15-1689, and 16-1465. City versus Ahmad Osman and Ahmad Alzein, property located at 12415 North 59th Street with a lien amount of $131,715. In case number 06840, this was a repeat violation case with overgrown conditions, minimum housing with broken windows and a broken door, and duty to keep premise clean. With 12 inspections costing $525, my recommendation is not to reduce the lien and leave it at $500 due to the home being a health and safety issue. I have a photos, if you would like to see that, of the home with the broken windows and broken door. In case number 13-1787, this was a repeat violation case with overgrown conditions and duty to keep premise clean. that accrued a lien of $1,500, with 14 inspections costing the city $575. My recommendation is to reduce the lien down to $750. In case number 14-1820, this was another repeat violation case for overgrown conditions and duty to keep premise clean that accrued a lien amount of $540, with 13 inspections by the city costing $545. My recommendation is not to reduce the lien and leave it at $545. I'm sorry, $540. In case number 14-2840, this was a duty to keep premise clean and boarded up structure that accrued a lien of $50,000, with 26 inspections costing the city $990. Due to the slow response by the owner, my recommendation is to lower the lien to $4,000. In case number 15-1476, this was a repeat violation case for overgrown conditions and duty to keep premise clean that accrued a lien amount of $850. With 10 inspections, the city cost is $445. My recommendation in this case is not to lower the lien and leave it at $850. In case number 15-1689, this was a chain link fence that was constructed without the required permit that accrued a lien of $77,475. With 27 inspections, the city cost is $1,030. My recommendation is to lower the lien amount to $2,500. This was not a health and safety issue. Case number 16-1465, this was an overgrown condition case that was also a repeat violation that accrued a lien of $850. With 8 inspections, the city cost is $375. My recommendation is not to lower the lien and leave it at $850. If my calculations are correct, with the 7 cases presented tonight, my recommendation to the code board is to lower the lien from $131,715 to $10,000. Just want to let the board know that the city cost totaling $4,485, that was based on all repeat violation cases. So again, if you decide to go with the city cost tonight, I would double that amount because you got to remember there was a violation case that was presented to the board and as well as the repeat violation. So I base my inspections based on the repeat violation cases. So that would be my recommendation. I just want to also say that each petition, well, I'm going to say majority of the petitions have stated that they never received a mailing from the city. Well, I have copies from each case showing returned certified letters with his signature or somebody's signature receiving the mail. So, so I have testimony and I have, like I said, certified copies of each case that somebody was receiving the certified letters. Okay? And also, him saying that based on the overgrown conditions, it took him 7 years to figure out how to hire a landscaping service to maintain his property. Each petition says something to the fact of that he had to figure out how to maintain the property. So that's my recommendation tonight. Does the board have any questions for me?
This is one property.
This is one property that we're presenting tonight. He also owns another property that I'll present later on after this one. Yes, sir. I'm sorry.
I mean, you went through,
Mr.
thank you, kept meticulous records about each one of your inspections. These are all, when you say violation 13,787, we did 12 inspections, and then the next one you did 14. Is there any kind of concurrency there when you go out to, were you inspecting for all of these violations, or are these individual visits to the house?
These are all individuals to the house.
Wow, thank you.
Yes.
That's, so, correct me if I'm wrong, that's 110 visits?
Yes, based on now, these were not my cases that I presented to the code board. This is based on what I observed from the screenshots of each case. How many times they went out there, inspection. So I'm basing that on that screenshot of each case. Okay, so I did not go out there 110 times.
Mr. Lloyd?
Multiple questions, I'll ask them.
Okay.
Case 14-2840, did I understand your recommendation correctly? What was the dollar amount?
Case number 142840.
Yep,
This was the duty to keep premise clean and boarded up structure that accrued a lien amount of $50,000.
and what did you recommend?
With 26 inspections costing the city $990. Due to the slow response by the ownership, my recommendation is to lower the lien to $4,000.
Oh, okay, I wrote 12,000, so when you said 10,000, I was going,
Yes.
well, that's less.
Some, I understand.
2 repeat violations. You recommended a dollar amount, and when I looked over these before the meeting, I noticed there were lump sum amounts that were assessed. Does that recommendation include the lump sum amounts for the 2 repeat violations?
Well, there's 4 repeat violation
Okay,
cases.
well, I guess the one I have in question, let me ask you this. What do the first 2 digits of the case number represent?
The year
Thank you. So case number 06-0840,
is 2006.
repeat violation. I believe your recommendation was to leave at the $500.
That's correct.
But when I looked at the minutes, there's a lump sum amount of, what was it, $700, I believe? Let me see here. We've got so many of them.
On my petition here, it says $500, sir.
For the lump sum?
06-0840,
Yep,
it says existing fines lien total, $500.
okay. And then as far, then let's go to the other one that I have here, is the one, 13-1787. It has a lump sum of $200. Is that included in the recommendation of $750?
13-1787,
Yes.
that's a repeat violation case, accruing a lien on $1,500.
And you're recommending $750.
That's correct.
Does that $750 include the $200 lump sum?
Yes,
It does?
yes.
Okay, and that's going to be the only thing I'm going to ask on the other repeats is if there was a lump sum amount, is it included?
Yes.
In that recommendation?
Yes.
Okay.
Any other, Mr. Snelling?
Just a point of clarification, did you, the $10,000 that you're recommending, did you say that does or does not include the city costs? I was a little confused on that.
That does not include city costs. But I want the board to know the amount of the city costs. If you choose not to take my recommendation tonight, at least you know how much it costs the city, and we always like to cover the city costs. So I gave you the numbers on that already.
One more question.
Mr. Lloyd? I hope it's good, because I
yeah.
hope it's my question.
Oh, we read case number 06 that you said was 2006. What is the latest date of violation of case numbers?
Well, the latest.
How long has this property been running, requiring all these inspections? From what year to what year?
The latest one was the fence violation.
Okay.
Where the owner pulled a permit to close that one out. It took him, almost, I think, it took him quite a while because that accrued a lien of $77,000, and that was in 2015, and he just obtained the permit in 2018.
Have the neighbors, has this property been a blighted property since '06?
Yes.
Based on your testimony?
Yeah, I wasn't, I've never been the zone inspector in that, but based on what I've seen here tonight, yes, yeah. Yep. And I mean, he's come forward now because he has received the demand letter from the city attorney, and that's what is making his, to move forward with this property.
Okay. The Going back to Mr. Snelling's question, and your recommendation for this lien reduction is $10,000?
That's correct. That's based on my
And
recommendation.
that covers the city cost?
Yes, it does.
Okay, thank you.
And just to confirm, you said the city costs are $4,485?
Yes, but that's based on a repeat violation. So if you, for a repeat to happen, a violation had to be presented to the code board previous to that.
Okay.
So I would just, if I was in your chair, I'd probably double the amount.
Back to your number anyway.
Right.
Okay. Any other questions?
Yeah, I just need clarity on the amount for one case.
Okay,
15-1476. That's the one that I think your amount was the same as the lump sum,
the,
recommended amount,
right, this was a lien amount of $850,
right?
and the city cost for $445.
Uh-huh.
And my recommendation is to leave the lien at $850.
Okay, because it was, okay,
Every time I get.
got it?
Okay.
It's all silent, but it's
Sure.
5 minutes.
We're just asking to see the signatures on the certified mail.
These are the ones starting in '06, and then you can go on from there. Okay, it's all there.
This is not me, definitely. Who's Robert here? Yeah, this is Robert, he's my house manager. So you have a style of Robert. This is NJ, this is the front desk bill. See, the old where I received them, but the violation corrected, but I'm not really sure of the dates, but definitely I didn't know that there is punishment. So those are all people that, yeah, they work for me, but those are all old before the address change. Like, for example, the fence was after all this. So, like, I don't know what's the, anyway, this is the change now, okay.
Excuse me, were you both sworn in?
Yes. I'm attorney, so I'm not providing testimony, just presenting argument.
Could
But-
you state your name and address you are speaking?
Yes, my name is Attorney Abraham Shakfe at 400 North Ashley Drive in Tampa, Florida, 33602.
Thank you.
We really appreciate Mr. Brony's recommendation. Dr. Osman is currently in compliance with all the issues that were that have been brought to his attention. Now with the notice of violations, these were signed off by his office staff, but recently the ownership address was changed to somewhere more accessible to him, so he's gonna be keeping a closer eye on all this. But that $10,000 that Mr. Baroni recommended, we appreciate that, and we hope that the board will follow his recommendation.
Okay. Thank you. Does Mr. Osman
Yes, sir.
want to speak?
Yes, well,
Name and address, please.
Ayman Osman, 7442 Terrace River Drive, Temple Terrace, Florida. Initially I was communicating with Mr. Emir, and we were always calling, he was always calling me, and I'm calling him back. And my understanding that he tell me about a violation, and then I correct it. And so many times I get a letter after the violation is corrected. I never really knew that the fine will be daily. In regard to like overgrown grass, sometimes I will, because I used to live in Brooksville, which is 50 miles away, so it's a 100-mile round trip. And it's really difficult for me during my business hours and then the hospital route and everything to come here and go back. It's really not that easy. So I would assign somebody here to go and take care of the property, and I pay them. And sometimes they were not doing the job, but they were taking the money. And, I'm not here that often, and I wouldn't know. And in some instances, there was somebody in the house, and he's supposed to take care of it, and unfortunately, he doesn't. So I call him, and he tell me I will, and to the best of my knowledge, that he should have. And then Mr. Amir will call me, and I'll tell him, okay, I'll take care of myself, and then I take care of it. But meanwhile, it will come here, and then my understanding that the violation was like one-time thing, that because it was corrected. But then later, I knew like the fence problem, for example. Mr. Amir advised me to put a fence because there were people breaking in an empty house. So I followed his recommendation, I put the fence, and I didn't really know that I need a permit for that. And I was like 30 feet from the street. And then he called me and he told me, you need a permit. Honestly, I have no idea how to obtain a permit, where to go and who to talk to. So, again, my schedule is extremely busy, honestly, and so many times I go back home at 1 o'clock in the morning. You know, patient care is really demanding, and I can't really let family kind of like not returning their call or a patient not seen in the hospital because I have to do this. Now, that does not really have any impact on you guys. That's my problem, that I got myself too busy and I didn't really control my schedule load. But the fact is that I didn't know. He told me you didn't pull a permit. I told him I didn't know. He told me, well, you are in compliance. That's going to be my report, so I think that it will be okay. The worst to happen, they will fine you $500, but I don't think they will do that. So then I called him after the meeting because I couldn't really make it. And he told me it was a surprise to me, but they decided to fine you because you didn't pull a permit. But I told him, like, so what's the chances of me getting this reversed? And he told me it's kind of difficult. You can try, you can come and ask. And so all what I thought, my impression, that it was a $500, it's fine, I'm in compliance, I didn't know, it's not the end of the world, I didn't hurt anybody. Actually, I'm doing it so I prevent people from breaking in from the back door. It should be really commended because, like, I'm doing fine. I did have security system, and police were called a few times because somebody breaking the glass, and it has the alert when it has a glass sensor. And then after 2-3 times, the police department told me that we're going to charge you $500 every time we come here. Okay, well, I'm not there, and it get to the point that I may have to sell the property, and I didn't want to do that. So I put the fence because of all the good things that needed to be done. I paid thousands of dollars for that fence. So then I learned, then he told me that I'm in compliance with the code, but my problem, I didn't pull a permit. I thought that it's a $500 fine, it's difficult to take it off, and okay, what can I do? You know, I'm in Brooksville, I'm busy, it's $500, it is what it is. So, and then only recently I came here and I was told that it's, I think, like $500 a day. I say, like, what? It's a $3,000 fence, and I'm getting fined $500 a day just because, I mean, it's in compliance. I just didn't pull a permit. I didn't know that, you know. I don't do building and repairs in my life, you know. I never done it before. I never knew what a permit is. So, and then I got this notice that they're gonna foreclose on my property. I said, like, foreclose for what? I mean, what's out there? And then I got the information that there is all this big lien. And it was like a shock to me, because to me, all what it is, it's a fence without permit, but it is in compliance with the code. It's an overgrown grass that was cut, and there is a tenant there that should take care of it, didn't take care of it, and sometimes there was no tenant there, but I'm over there, and I, you know, didn't take care of it on time, but I did take care of it. So, and see, at the same time, my property is really kind of like on the edge of Temple Terrace, because you have to come out of Rain Tree and make a right, and I'm the only property that's Temple Terrace on that corner. Everything else is Hillsborough. So, you know, it kind of like, it didn't bother any resident of Temple Terrace. So I was in a shock. Initially, like, I said, you know, I need to do something about it, blah, blah, blah. Then I said, I can't handle it myself. I never been in front of a crowd like this before. I didn't know what to do. So, and a lot of what he said, I heard it for the first time. And I came here with a lawyer thinking, I may need some legal advice. And when I'm listening to what he's saying, I say if I get away with the $10,000, although it's for minute things, kind of like, what can I say?
Well, I've been on the board for a while, and this property's come before us many times. And I appreciate that you're willing to come here tonight and for the lien reduction. And also to see that you stated that you're now living at 74442 Terrace River Drive.
That's correct.
Welcome back to Temple Terrace.
Thank you.
It's an annoyance to you, but it's also annoyance to other people in the city. And your property happens to be in the city. What happens in the county is not our problem. We get to look at it, but it's still not anything we can do anything about. So that's the explanation of what's next, what's behind you over here. So I'm glad you're here before us tonight.
Thank you.
And I'm glad that things have come into compliance because it's really important. That's what we
absolutely.
strive for. So,
And the last violation of the fence, it's been years ago. And as I said, it's according to the code, it just didn't have the permit. And when I learned about it, I went and I got a permit. I didn't know that there was fine every day just because I didn't have the permit. And the permit didn't cost me like $100. It's really no big deal.
right. Are there any other questions? Mr. Lloyd?
This property, is it a rental property, income property for you?
Not really. It was property that I bought for me to live in it. My wife didn't like it. And then because of receiving letters like this, I found a guy who had some financial issues. I told him, okay, would you stay in that property for free just to keep it in compliance? And I was paying all the taxes. So he was just sitting there for free, for nothing, just for me not to stop getting those letters. And apparently he didn't do such a good job. And then when he left, I got to learn, I start getting the calls again from Mr. Amir, and I get to learn that him and his wife got divorced. She left the house, he left the house, and they left it just vacant, and nobody told me. I didn't know. And of course, he didn't really care because he wasn't even paying rent. So, I mean, I kind of just because I don't have time for any headache, and that was a shortcut for me, and I compromised, and he was poor. It was kind of like charity, and, it kind of like when the first Hispanic guy came forward, and I thought it's all about $50 for his tag. I told him for God's sake, I'll pay it for him. I'll do it online because you can renew the license plate online, and not for him because it looks to me he didn't really understand how the system worked, blah, blah, blah. I said and then he told me, just calm down. This is not your time to do people favors and to do charity. And then I learned that there is a registration issue, then it's a 5-year, and it's good that I kept my mouth shut. But I really...
Go ahead, just for the sake of experience, since '06, have you received any income from this property?
No.
Okay.
Not a penny. Actually, I'm paying my taxes and, everything that needs to be fixed and repaired.
Okay. Mr. Westfeld, did you have a question?
I don't have a question, no.
Anyone else?
Is
There-
the home occupied now?
Yes.
Okay, what, 6-month lease, 12-month lease, or are you living in it?
No, it's supposed to be a year lease.
Okay.
But, kind of like this another story. The tenant, he moved in because he need to fast, and then he is not signing a contract. And I told him, if he's not signing a contract, I need to, let him go.
So you don't actually have a signed lease at this point?
No.
He's in it, but it's just, there's nothing agreed on.
That's true.
Okay.
But see, now that I live here, it's kind of like completely different ballgame. I'm 10 minutes away from the property. Although I live in a townhouse, so I don't really have somebody who cut my lawn and but everything I need, I can take care of it myself. It's different that, and the other thing, I cut down on my hours because I realize working from 6 to 1 is not really life. You can't really take care of your kids, and so I cut down now to 2 almost half days in Brooksville, where I've been there for 20 years, and 2 days here. I have an office here next to USF. So, you know, to me, I'm kind of live here now. So it's my backyard. So even if the tenant is not there, the tenant is there, it's really not a problem for me anymore.
Thank you, Mr. Hubert. Do you got any further comments that you want to share, or are you finished?
I was so actually nervous coming here, and from what I saw so far, I'm a lot more comfortable.
Very good.
Thank you.
That's a win too, isn't it?
It is indeed.
For us. Thank you.
Thank you.
There being no other questions and no other persons to speak, I call for a motion.
I'm happy to make the motion, but I'm going to have to guide me a little bit here. Are we just making a motion whether or not to accept or not accept? Okay,
This is a new script that's going to be presented.
perfect, okay. Okay, let me give it a shot.
Sorry I didn't get a chance to get it to everybody. I guess we'll give it a trial run.
Okay, now here we go. In the lien reduction petition case numbers 06-0840, 13-1787, 14-1820, 14-2840, 15-1476, 15-1689, and 16-1465, City versus Ayman Osman and Asmaa Alzein, is that correct? Address located at 12415 North 59th Street. Upon hearing the facts and an argument from the city and the property owner, I move the board recommend to city council that the fine be reduced from $131,715 to $10,000, contingent upon the fine being paid within 30 days of the council's decision, or it revert back to the original amount of $131,715, and the city is authorized to enforce the fine in accordance with the law.
A second? Second by Mr. Hubert. Any discussion? There being none? All in favor? Aye.
Aye.
Opposed? Nay?
Nay.
2 nay. Mr. Lloyd, Mr. Westfall. Motion carried.
This will be the second lien reduction. Good evening, Tom Baroni, Code Compliance Director. At this time, I would like to introduce this lien reduction petition request in case number 18-2006, City versus Ahmad Osman, property located at 7442 Terrace River Drive with a lien amount of $4,600. This case originated back in May of 2018 for an inoperative vehicle. A notice of repeat violation was issued on June of 2018 and was brought into compliance on October 18, 2018. With 13 inspections costing the city $545, my recommendation is to lower the lien from $4,670 to $2,300 due to being a repeat violation case. If the city has, if your board has any questions for the city, I'd be willing to answer.
Mr. Lloyd?
Are there any other outstanding debts that are not part of this violation?
Not that I'm aware of.
Okay. On the lien reduction petition here, under finance, it says there's $144.53. Is that included in your $2,300?
Yes, it is.
Thank you.
Any other questions?
I guess I should ask the second question first, sorry.
It's okay.
Mr. Osman?
Now, inoperable vehicle, what was the problem with the vehicle?
What was the tags? The tags.
Expired or no tag?
Expires.
Okay. The vehicle tags were expired.
Okay, the vehicle tag were expired, but see, I got a little confused with this because I thought that the notice that I was receiving was from the homeowner association. And it wasn't clear to me that there's going to be fine and the fine is going to be daily. So, the tag was renewed with the DMV. And I thought that is sufficient. The thing that I just neglect to put the tag on the sticker on the tag. But the tag was renewed and the vehicle legally was operable. There was no problem operating the vehicle. And all what I thought that if I stopped by policeman and I can either jump to the back and stick the sticker because it was always in my pocket.
You missed it.
Or I'll get a ticket, and if I already paid, renewed the tag, then in court it will be $10. So it wouldn't really be an issue.
Well, unfortunately, it was an expired tag that was the violation. And the fact that it is, you had or didn't have, and you say you had the tag updated but didn't put it on, what the city sees is still a car that's there with the violation, a tag that's not up to date, which could be an inoperable vehicle as far as what we as the city enforcement team would see. So you know different, but we don't know different. So until the tag is put on the plate, it's a violation.
Yeah, I thought that somebody would check with the DMV and would know, same like police, would know whether it's done or not.
Well, it's kind of falls back on you because you're the one that puts the sticker on the plate. And so it goes back to the same thing, that it wasn't there. We don't go and check every tag in Temple Terrace that, other ones that are in violation, you've seen several tonight that have come up before us, that it's a violation if it's not tagged properly. And if it's an inoperable vehicle with the wheels off, it's, those things do count. There is a code violation that it's based on. It's not just that it happened to be you and we're driving by and it's seen as a violation. We don't know that you have already updated this sticker.
Yeah.
Mr. Lloyd?
Did I hear you say that you received the notice, but you thought it was from the homeowners association?
I thought it was
Okay.
from the homeowners association.
Okay. Because there was a $750 fine that was part of that notice that was already assessed on you for that violation. So I'm kind of having a hard time understanding, to get to that repeat to be that much, you had to have been out of compliance for a while
I
on a
don't
repeat
recall.
violation.
I don't recall I received any letter saying that there is already a
You just
seven-
said you did, so I'm confused.
No, I received a letter saying, or actually, what I remember, what I recall, that this yellow tag, the note that they put on the windshield. Okay, that's the one that I remember I received. Now, I don't recall that there is other letters by mail that I received. Now, do they send a letter every time they come for inspection, when they say like, they did 13 inspection? How would we know?
I was asking the question because I thought you stated you'd received the letter, and you did, and the dollar amount is in there that you were fined that amount.
I
so.
don't recall
Okay.
that at all.
All right.
There's two letters that are sent out. It's the notice of repeat violation that was sent out to him, certified in first-class mail, and also the order from the board is also mailed out certified in first-class mail.
And does it say it's accruing fine
Yes.
and it's $750 now?
I have a copy of it right now. to show you.
Okay, all right.
Okay.
I must have missed that. I don't know what to say, you know?
Okay.
I'm asking for the leniency, so.
In furtherance of that leniency, we do appreciate Mr. Bereni's recommendation of reducing the lien. He, you know, there's no public safety issue. The car is, it's not, you know, the rule is written in a very interesting way. You know, it covers everything from just spare parts sitting on the driveway to, you know, Dr. Osman's car, which is fully operational, just doesn't have that tag. And because it's on the lower end of that spectrum, we do believe that Mr. Bereni's recommendation is appropriate. And there's, the community development's not harmed, it's not a utility issue, so we do hope that there would be a reduction.
Okay, thank you. Mr. Byrne?
I just have one other thing there. Jose Silva was the inspector for that case. Jose was the inspector. He hand-delivered the notice of a repeat violation to this gentleman.
Okay.
Okay.
All right, thank you. Any other comment, questions? Call for a motion?
He's closest to the new sheet.
No, you have one. I passed around.
Ah,
He passed his on.
problem is, I'm not the one to be making a motion on this case.
Okay, well, maybe we need someone else.
Actually, can I ask one more question? Sure. So, through all of this, we've sent how many dozens of notices? And, like, you know, just hundreds or whatever it may have been. What's changed that you're gonna get anything that we send you now? If we're lenient now, what are the chances that this is gonna happen again and you say, oh, I didn't get anything?
No, it's just not gonna happen again.
Right now, he knows that there's a letterhead from the HOA and an HOA, and a letterhead from the city, and he'll be sure to be cognizant of that.
Okay.
No, it's just not gonna happen again, you know? If you see me here again, then you can do whatever you feel like it, but it's not gonna happen again. We have two homeowner associations, and I have other properties that have homeowner associations, and their name is Terrace River or Temple Terrace, and there is common names, and, you know, I'm not gonna say that I didn't receive them, I didn't sign them, but I definitely didn't, read them. It could be that I took it, could be that somebody else at home took it, it could be that I put it with other mail and it got misplaced. I'm not saying that I'm not at fault, it's not my fault, and I didn't really understand the system. I thought that if I have the tag renewed, then the issue is gone. You know, now I know the system, and there was definitely no malicious intent. I didn't really mean to ignore the city or anything like that. It's just one of these things that you don't know, and you're busy, and, you know, basically, by the end of the day, I'm the one who's getting screwed, you know, it's kind of like nobody hurt, no harm done. The tag was renewed and the tax on the car was paid, and I'm here apologizing and begging, and who like that? Who want to be that person? So, but, you know, hopefully we'll put it behind me, whatever you guys decide, I'm going to accept it and pay more attention and, you know, move on. And I just hope that, you know.
Thank you.
Thank you. Thank you.
Continue to call for a motion.
What was the recommendation by the city, again?
$300.
$2,300.
Down from like 47 it was?
4670.
Okay. Okay. In case number 182006, for the property located at 7442 Terrace River Drive. Upon hearing the facts and argument from the city and the property owner, I hereby move the board recommend to the city council that the lien be reduced to $2,300 from $4,670, contingent upon the fine being paid within 30 days of the council's decision, or revert to the original amount of, was it $50 a day?
No, 4670.
4670.
No,
Revert to the original amount of
oh,
4,600.
Yeah.
and the city is authorized to enforce the fine in accordance with the law.
Do I have- Second by Mr. Newkirk. Any discussion? All in favor? Aye.
Aye.
Opposed?
Nay.
Was it two? Mr. Lloyd, Mr. Westfall. Okay. Mr. Osman, this recommendation will now go, both recommendations from previous and this one, will now be scheduled for a final determination by the city council at a subsequent city council meeting, which will be in January. And I will attend the meeting to present the request from the board. And I encourage you to attend this meeting, as you will be given an opportunity to speak on the matter by the city council. If the council approves the lien reduction recommendation, you would have 30 days to pay the lien reductions, or it would revert back to the original lien amount. You understand that?
Yes, sir.
Okay. All right, and you will be noticed when, so you can keep an eye on the mail from City of Temple Terrace, that it will be coming in January for one of the meetings. It's either going to be the first or the second Tuesday of, first or the third Tuesday of January. Okay?
All right.
All right.
Thank you.
Thank you. You have a good night.
If you'll indulge me for a second, I just want to comment about these to the city.
Also, she has a correction.
The first is January 1st, so it won't be the first.
It won't be the first. Okay. So it'd be, all right, go for the third.
All right.
All right, see you there.
Thank you.
All right. Did you need them here?
No, I
for
just
this?
wanted to say something
Okay.
to.
All right, thank you. I do too.
I'll make it quick. I just want to say that I recognize the hurdles we've had with lien reductions, and I appreciate what you've done, and
Okay.
my vote in no way is a reflection on you guys and the work you've
No, I
done. This is a difficult path that we've gone down.
Right,
And
right.
I appreciate the method and the recommendations that you've brought forth.
Yeah,
I
yeah.
think it's a much better process than what we've had in the past.
Okay,
So, and I just want to make sure, I know it's not just you, you have a team helping you, as well as the city attorney serving
Right.
these notices, so, I just wanted to say that.
I
And really
appreciate
the
the pat on the back, and I do put a lot of time and thought into each lien reduction. So I don't just make up a number. I try to be consistent and be fair. But thank you.
effort. And that's best, thank you.
New business, but we have one person missing, and I'm down that trail pretty soon too, so if we can move it along. Mr. Mueller,
Unfinished cases?
Unfinished cases.
oh, I'm sorry. I'm finished.
Unfinished MTV cases. Case number 18-3407, City versus Estate of Antonio Andux for the property located at 512 Caroline Street. An affidavit of compliance was submitted for sections 10-3B, 8-102-18A, and 8-102-13C by Officer Doug Allen, dated November 16, 2018. Case number 183726, City versus Rodney Thomas and Amanda Hairston Thomas for the property located at 8644 Navajo Avenue. The expiration of compliance is tonight at midnight. An affidavit of compliance was submitted for section 12-8593 by Officer Doug Allen, dated December 3, 2018. Case number 18-3885, City versus Diplomat Property Manager LLC for the property located at 107 South Greenfield Avenue. The expiration of compliance is tonight at midnight. Case number 183940, City versus Esther Elizabeth Foley for the property located at 8712 Coral Dawn Court. The expiration of compliance is tonight at midnight. Case number 184002, City versus Anthony and Jillian Moore for the property located at 841 North River Hills Drive. The expiration of compliance is tonight at midnight. An affidavit of compliance was submitted for section 8-28A1 by Director Tom Baroni, dated December 6, 2018. Case is not on the agenda. Repeat case number 183920, City versus Craig Bernstein for property located at 418 Ferncliff Avenue. An affidavit of compliance for section 12-8592 was submitted by Officer Silva, dated November 16, 2018.
Wonderful. Thank you. Mr. Miller, would you want to talk about the sheets that, the things that you prepared, or are we good? Like the lien reduction?
Right, thank you. I was going to ask if the board likes the motions. I'll clean them up. I see there's a couple typos in it. I apologize for that, and I can get clean copies to the clerk. I'll probably run it through the city attorney, that'll get it to the clerk, and that way you'll have it for the next meeting if the board likes the motion.
It was very helpful tonight.
Yeah, no, I agree.
So, okay, any other old business, new business? We have an election tonight. And ask for a motion for chair.
I mean, to me, I think you're doing a wonderful job, so I'll nominate you to be chair. I mean,
I'll accept it.
yeah.
Need a second, though. All right. Thank you. Any discussion? There being none. All in favor?
Aye.
Opposed? No nays. Thank you, guys. Now, we have a vice chair that needs to be nominated, and do we have a nomination for vice chair?
I would like to nominate Board Member Westfall.
Mr. Westphal?
Thank you. I appreciate that. It's up to you guys. I mean, I do feel like.
Second.
Second, okay.
All in favor?
Aye.
Opposed? No nays. Congratulations.
Thank you.
You get to move down the line.
I was gonna ask if it's a new seat.
I like my seat. Oh, all right.
All righty.
I wasn't why I made the motions to move you away from me, all right?
I was about to do it
For the
to
record
you.
there.
I was about to do it to you. You beat me
All
to
right.
it.
Sorry to be out of order there, but I had to say it.
Mr. Barone, do you?
Be very brief, I'm sorry. Mr. Golerich, I'd just like to welcome you back, sir.
Thank you.
This brings back a lot of memories. When I see you up there on the code board side, it brings back a lot of good memories. So I just want to let you know that in case number 170570, this was a lien reduction case that was presented to the board. They paid their $575, and also that was the one with the raccoons in the soffit.
Oh, yeah.
That gentleman paid his lien. And the other one was Nelson Claros. This was, I think this was a rental, is this a rental permit? Whatever, they paid their $2,500, that lien. So just wanted to update the board. And I
Good,
just
and
want to wish
that's-
everybody a happy holiday and a safe one, and a happy new year. Thank you.
It's okay to say Merry Christmas.
It's okay.
And I wish you all a Merry Christmas
Same to you.
and a Happy New Year, because we'll be meeting again in January.
I'll make a motion.
Can I mention,
All right.
I wanted to mention one thing for new business.
Okay.
Is it possible that we could keep everything to 3 minutes? Use a timer like city council does? Is that something we could do?
I think you could,
I was told it was for guests or other people besides the respondents.
Yeah.
Okay,
yeah.
okay.
Well,
Maybe,
I would say that I think the chair, if you see it running over, or running on, or beating a dead horse, or whatever you want to call it, I think you have the power to stop it. And you might want to use that gavel a little more. But I don't know that we can tell people it's only 3 minutes, because like she said, if someone were to come up in front of council, that is not on the other business side of things, where you fill out the form, we give them, up to 15 minutes sometimes, or longer, to present their case. So I think the respondents have the opportunity to get their due process, and I would hate to see somebody think that they're not getting the due process because we cut them off after 3 minutes. However, I think the chair has the power and the responsibility to, if things are going too long, or if they're rehashing.
If they go back into the rehash.
They go back and rehash it, or they're talking about, I mean, there were some things that he said tonight that, quite frankly, had nothing to do with anything.
That's true.
And, that you could have just, thank you very much, let's move on. So,
Well, we did try and interrupt him, both Sean and I.
Yeah.
Well, and to the point of, I know I'm long-winded, so feel free. And Mr. Miller, if for some reason you see that maybe I'm going off point as far as, I'll welcome the feedback for, at the time or at the meeting that isn't relevant to the case, or it's not, you're being redundant with your questions, feel free to educate me on that.
Well, sometimes we.
That'll be for the chair to really do, but, just to follow up, just so you understand, as it was said, due process, one of the prongs of due process is the meaningful opportunity to be heard. That's why you don't really want to put a time limit, but once things get reiterative,
And that was kind of my point.
repeated, everything else, it's no longer, you can cut that off.
Well, that kind of is relevant to the fact that if we ask too many questions that drag it on too, it gets to the way the same
Or
thing. Because
irrelevant
the
questions.
more we say, the more they say, or whoever else talks, they get another chance to respond. So we all have to keep that in mind too.
And-
Sorry for the new business, but yeah, I'm making a motion to adjourn.
I'll second.
All in favor?
Aye.
No noes, no nays.